Good morning, everyone. Welcome back to our channel for continuation of our criminal law series. Those who are attending today for the first time, please ensure to go back to our channel and watch the previous discussions we have had. In today's live session, we will delve into the art of conducting chief and cross examination in criminal trials. Effective examination of witnesses is crucial for presenting a compelling case and uncovering the truth in legal proceedings. In this session, we will provide practical guidance and expert strategies for conducting both chief and cross examination with confidence and proficiency. From preparing your questions to eliciting key information, we will explore the nuances of questioning witnesses to build a strong case for your client. Whether you are a legal professional honing your trial advocacy skills or an individual navigating the complexities of the criminal justice system, this session will equip you with the knowledge and techniques to excel in examination. So don't miss out on this opportunity to enhance your advocacy skills and achieve success in criminal trials through effective chief and cross examination. I welcome back our speaker for the session, Veeta Bajwa, an accomplished criminal lawyer with an impressive 14 years of experience specializing in the realm of criminal trials. A very warm welcome, ma'am, and over to you.
Thank you so much, Swatileka. Good morning, everyone. So, your today's topic is on chief examination and cross examination. Now, before we go to chief examination and cross examination, there is some basics of the Evidence Act which everybody needs to know and which needs to understand before you conduct a chief examination and a cross examination. Now, that would be that what are the types of evidences in law and how are they to be proved, and what exactly are the evidences which are to be led in the chief examination, and what is the evidences which has to be led in the cross examination. So there are three types of evidences. One we have as a primary evidence, second we have as a secondary evidence, and third we have as an electronic evidence. Now, your evidences are covered under the Indian Evidence Act. Your primary evidence would be that any document or anything in its original form is called as a primary evidence. For example, your original copy of the FIR, your original birth certificate, in the charge sheet you have statements of witnesses, which are the statements recorded by the police with the stamp of the police. Those are the originals. Or your original postmortem reports, your forensic reports by the CFSL, the original reports. Those are called as primary evidences. So anything which is in its original form is called as a primary evidence. Certified copies of the orders are called as primary evidences. Second, you have which we call as secondary evidence. And in what cases do you lead secondary evidence? Secondary evidences are those evidence which is anything which is a photocopy or a copy of the original. For example, say I have lost the original copy of the a birth certificate, so I get a Xerox done, or I have a photocopy which I place it on record, and you will have to mention the reasons to the court as to why the original is not being able you're not being able to produce. Where exactly is the original? There are certain criteria under section 65 of the Evidence Act which lists down in what cases secondary evidences can be led, whether if the original has been misplaced or destroyed, or if it is in the possession of the other side, or if it is in such a place from where it is impossible to retrieve it. These are called as secondary evidences. Sometimes you would encounter in a lot of cases that there are documents which you do not have, but you need to rely on those documents, and that documents are in the possession of the other side. What do you do in such a case? You file an application under section 66 of the Indian Evidence Act, wherein you ask for production of documents from the other side, saying that this document is in your possession, and you ask the court to direct him to produce that document. Once that application is filed, the other side files their say. If they have it in their possession, they produce it. Maximum time you would notice that they do not produce the document. Okay, so at that time the court draws an adverse inference, and then a photocopy of that document is relied upon. That is why it is called as a secondary evidence. You have fulfilled the criteria to lead the secondary evidence. You filed an application for production. You called upon the other side to produce the document. They did not produce. And that is why now you are relying on the photocopy. And then the court will take the photocopy on record. You will prove that document, and the court will consider that document as an evidence. That is called as secondary evidence. Now you have something which we call as electronic evidences. Now with time, with technology, this is something which we need to change with times and rely upon. Now you would encounter in a lot of trials that maximum kind of evidences nowadays are in electronic forms. For example, your WhatsApp chats, your video recordings, your audio recordings, your CCTV footages, all these are second electronic evidences. Now anything which is original, for example, say if I have this phone and I record a video or an audio on this phone, and when I produce that, okay, now the audio or the video recording in the phone would be a primary evidence. I have to produce that. If I take out a printout of it, or if I put it in a pen drive, that becomes a secondary evidence. Though it will be an electronic evidence, it will be a secondary evidence. Once I produce, I can also do that. I can tell the court that I need the phone for my day-to-day purpose. So you can compare and verify the original with the copy. You can do that for documents also. If you need the document in other trial, or if you need the document for your personal use, you can mention to the court that the original may be compared, and the photocopy may be compared and verified with the original, and the original be returned back to me because I require. The same way in electronic evidences, you can get it, compare, you can verify, and you can take your electronic device back from the court. When it comes down to CCTV footages, you have something which we call as the hard disk, in which all the CCTV footages are stored. The device in which the CCTV footage, you have to produce that device before the court. Now, once all these are produced, you have to compare and verify with the printout or play it, and then that's how it gets exhibited. As I had said earlier, mere exhibiting of documents would not prove the documents, which has been clearly laid down in the judgment of Geeta Marie. What exactly do you mean by proving of documents? How you're going to prove the documents, that we are going to cover up in chief examination. Now, these are the types of three evidences: primary, secondary, and electronic. Along with the electronic evidence, you also have to produce a certificate under section 65B of the Indian Evidence Act, which this law has been laid down by the full bench of the Honorable Apex Court, the Honorable Supreme Court, in the judgment of P.V. Anwar versus Bashir, wherein the Honorable Supreme Court has clearly, categorically laid down the guidelines how an electronic document is to be proved, and why a certificate under section 65B is mandatory. Now, what exactly is a certificate under section 65B, and why that needs to be produced? A certificate under section 65B is a certificate given by the person under whose control that electronic device was. That person gives a certificate saying that this electronic device, this electronic printout has been taken from the device which was in under my control and without any human intervention. If these words, always remember, this is mandatory. It has to come in the 65B certificate. And he says that I'm the one who has given the printout. So this certificate is to be issued by the person who gives the printout, and or under whose control the electronic device was. A 65B certificate is mandatory as per P.V. Anwar versus Bashir. There is a division bench judgment also of the Honorable Supreme Court of Shafi Mohammed, wherein the Honorable Supreme Court has clearly held, the division bench had held, that 65B certificate is not mandatory. That judgment is pending for consideration before the larger bench. But till now, because the judgment of P.V. Anwar versus Bashir is a full bench judgment, is a 3 judges bench judgment, it will prevail, and it will upon the judgment of Shafi Mohammed. And that is why that law till today is followed and states that yes, a certificate under section 65B is mandatorily to be produced. Now going down, after once you understand these evidences, now let's come down to the chief examination and cross examination. What do you mean by chief examination? What do you mean by cross examination? Whenever a witness is put into the witness box and he deposes about his case, that is called as a chief examination. If he says what is statement, if he repeats, once he goes into the witness box and on oath, he repeats the statement he gave before the police, that statement is called, that deposition is called as a chief examination. Once he completes the chief examination, the defense gets a right to cross-examine him on his chief examination. That is called as cross-examination. Now, coming down to chief examination, you would ask that, ma'am, how to lead chief examination? What are the questions to be asked? Before I go down to that, you need to first and foremost understand, to understand that what needs to be asked in a chief examination. Before that, you need to understand what cannot be asked in the chief examination. The first thing that cannot be asked in a chief examination is a leading question. Okay. Second thing which cannot be asked is the opinion of a witness. Third things which cannot be, should not come in the chief examination, those are additions and omissions. Now, what exactly is the chief examination and how the person would depose about the same? For example, say I am Mr. A and I have deposed before the police that on 27th of June 1991 at about 5:30 a.m. I was traveling by my car at say Marine Drive, and during that time I saw the accused Mr. So and so assaulting Mr. C. If I say that, now I have to repeat that everything in my chief examination. So how will you ask? How are the questions to be asked? Always remember, in the chief examination, you are supposed to ask questions in which you get the answer. Your answer cannot come in the question. Now, what do you mean by that? For example, say if I have to say what happened on 25th of June. Now I want to get it from the person that what happened on 25th of June 1991. So I will ask him what happened on 25th of June 1991. And the witness has to stand on its own legs and the witness will start repeating that on 25th of June 1991 at about so and so time, I was traveling in my car bearing number so and so, and I had reached at so and so place and I saw Mr. B assaulting Mr. C. Now I want to say, if I want to ask him what was the mode of assault, how he was assaulting, so how will I ask that? I will ask them, at the time when you reached and you saw him assaulting, what exactly did you see? What was he doing? What way was he assaulting him? If I say what way, then that time the witness will answer that he was assaulting with a stick or with a knife or whatever you want, whatever was the weapon of offense. That's how you're supposed to get the answers from the witness. You cannot put questions wherein you will give the answer. For example, if I say that अच्छा 25th of June 1991 को शाम को 5:30 बजे आप जा रहे थे तो मरीन ड्राइव में क्या हुआ? If I ask a question like this, I am putting the answer in the mouth of the witness. This is called as a leading question. When I put the answer in the mouth of the witness, where the witness can only answer in a yes or a no, or the witness knows the answer in the chief examination, or he knows that what he has to say, that becomes a leading question. And as defense, it is your duty that you are supposed to take objections during that time. You're supposed to object and not allow leading questions to be asked, because because of it, always remember the law is very clear. The witness has to stand on its own legs. So if you are going to allow leading questions, you are going to help the witness, wherein the witness is going to know that what he has to answer during the chief examination, which would totally cause prejudice to the accused. Second would be an opinion of a witness. Now, what exactly do you mean by an opinion of a witness? Now, opinion basically means that wherein you ask a witness that वो आपको क्या लगता है, if a question comes like कि आपको क्या लगता है कि आरोपी को ऐसा करना चाहिए था क्या? What do you think that the accused should have done like this? This is, you are asking his views, you're asking his opinion, and that cannot be allowed in a chief examination. So again, as a defense, it is your duty to get up and take an objection saying that this is an opinion and this cannot be allowed in the chief examination. Second. Third would be your additions and your omissions. Now, what exactly do you mean by additions? What exactly do you mean by omissions? Going beyond what you state before the police, going beyond your complaint, something which does not come in the complaint. Some say incidences or some instances which has not come in the complaint, but now you are exaggerating you to fill in the lacuna of your case. You go ahead and say something which does not come in your chief examination. That would be additions, that would be omissions. So that is the reason why that cannot be allowed, because do you, as defense, object? If the court does not take your object, let the additions come on record. Let the additions come on record. The reason why you allow the additions to come on record is because during the cross examination you can bifurcate and you can get it in the point of omissions, saying कि आपने ये जो बोला है, this statement which you have stated in your chief examination, this is not a part of your statement before the police. That would be an omission. So that is the reason if the witness says something or in additions, always remember that you can allow it to come, or otherwise you can say that let it come, good for you. In fact, you take it as omissions in the cross examination, work in your favor, because then you can tell the court that this witness is not a trustworthy witness and he has a habit of improving their case, and that is the reason they have a habit of making improvements in the case. That these three things are to be borne in mind at the time of a chief examination. Now you also have something which we call as proving of documents. Now, how do you prove a document in the chief examination? Whenever a document is to be relied upon, or you want to state, say for example, I want to state about an FIR. Okay, an FIR was registered. I will first have to give a brief background as to how the FIR or how the document came into existence. That is called as a chief examination. That is called as to proving of document. So to prove a document, first a base story or a background has to be given as to how that document came into existence. So say if I want to say an FIR, so I would have to say that what was the dispute, what happened, why, what was the dispute between the complainant and the accused, what occurred, what was the incident, and why we went to the police station, and how the FIR came to be registered. Once you may mention about the FIR and you background, then you will say that the FIR was registered at so and so police station at so and so time. Now, that time, the prosecutor or the lawyer, who is, if it's a private complaint for the complainant, would seek permission from the court to show the original FIR to the witness. Once you seek permission, you would say that the court will say, yes, you can show. You show the original FIR to the witness. You would say, is this the same FIR which was registered by you? He said, yes. Does can you identify the same? You would say, yes, I can identify the same. What do you have to say about the contents? The contents are true and correct. If it has your signature, you would say, if it has the witness's signature, you would say that does it have your signature? You would say, yes, it bears my signature. I can identify. That's how you prove the document. You first identify the document. You mention about the contents of the document, that the contents are true and correct. And then you pray to the court that yes, now it may be taken on record, marked as an exhibit, and be read in evidence. That's how you identify. You identify the document, you identify the contents of the documents, you identify the author of the document, and then you get it marked as an exhibit. After proving, when it is marked as an exhibit, it is given an exhibit number, then the document stands proof. If you do not follow this procedure, you don't prove the document, you simply just prove it and the court marks it an exhibit, the document would not stand proved. You have to make a deposition about that document. You have to identify the document. You have to identify the contents of the document. You have to identify the author of the document. Also remember, as a defense, if that person is not the author of the document, you can raise an objection and say that that person is not the author of the document. Let the author of the document come on record. Let the author of the document be examined, and let the author of the document be examined, and he is the person who is the competent person to identify. For example, your postmortem reports, your forensic reports. You have something which we call as a CA, a chemical analyzer, or a forensic expert. When there are documents, or there is CFSM reports where for drugs has been sent, narcotic drugs are sent for examination to the CFSM. You have the CA report, which is called as the chemical analysis report. In murder cases, you have the PM report, the postmortem report. You have something which we call as blood grouping reports. All these reports for which we have the expert who makes that report. Now that expert is the only competent person who can come and prove that document. You cannot say about that document ki, this was sent for you cannot identify. No, it will have to be that person who made that document has to come and depose about the document and prove those documents. That is called as proving the documents. So in the chief examination, you first mention about what exactly is your story, what exactly is your transaction. Then you come down to your documents one by one. It goes as a story in stage wise, at which stage, at what stage, which document came into existence. We'll have to keep mentioning this document, how the document came into existence, and then see the document, identify the document, depose about the contents of the document, and get the document exhibited. Once you finish this, you are done. Then your chief examination is closed, and then the matter is placed for cross examination. What exactly is the cross examination? Cross examination is something which is the most integral part of a trial, something which is very, very important, without which a trial would not stand, a trial would fall, and something which you really need to master, because they say that cross examination is an art, and that is a fact. That is true. It is a art. It is a fact. It is a fact. It cannot be gone into. It cannot be done without, if you don't have any presence of mind. I remember when we had our seniors who used to cross examine, the best thing what we learned from them was that common sense. Use your common sense. The most common sense is the best type of questions you can ask, and something which you go on legally, technically, read judgments as to see as to on what grounds the high courts and the Supreme Court have acquitted the accused in a similar case. What was the observation, and what exactly was the lacuna which the honorable court relied upon at the time of acquitting the accused. So you need to see that. For example, say when you have offenses such as counterfeit currency, now under 489 of IPC, now when you have counterfeit currency, if you read the judgments, the main ingredient of a counterfeit currency is that the person who was circulating. Now before we go down to that, let me just appraise you of the law. As per the RBI, the law is very clear that if there are counterfeit currency deposited in any bank or caught with any person circulating it, if there are 4 notes, the 4 notes are to be destroyed immediately. If there are more than 4 notes, then an FIR has to be immediately registered against the person in possession of the counterfeit currency. Now, the main presumption under the law when it comes to counterfeit currency is that that currency was being used for circulation with a knowledge that this has to be circulated, and it was being used for circulation with the knowledge that it has to be circulated in public. That is what is the main ingredient, main presumption to be followed in a counterfeit currency. If the prosecution fails to prove that, then the defense in the cross examination, the defense has to get the evidence in a similar way that he was not aware that these notes were counterfeit, and he was not aware that this has to be this cannot be circulated, and this he was not using it for circulation in market. That is the main thing which you need to understand. Okay, now coming down to your cross examination, that's how you will do. You will cross examine the witness as to what he says in the chief examination. For example, you have hearsay witnesses. Now, what do you mean by hearsay witnesses? Hearsay witnesses are, for example, say I say something to Swatileka. Swatileka goes and says it to somebody else. Okay. Now, the third person to whom she goes and says, that third person comes and says, yeah, I'm aware about the incident because what happened with Birta because Swatileka has told me. So that person is not an independent witness. That person is not an eyewitness. He cannot depose. It's a hearsay evidence, because the evidence has gone from one person to second to third, and if the third person comes and deposes about it, then it is called as a hearsay witnesses, and those cannot be allowed. So you have to take that, whether he had the personal knowledge about that incident, or he had the personal knowledge about the evidence which was being deposed. You have, that is the main ingredient. Then you will cross examine upon, for example, on the spot, if it's a pancha, so whether the he is deposing properly about the spots, whether the directions of the spots was proper, whether the location is proper, whether if the you are the picture of the spot wherein there was this shop, where that is proper. That all things have to be got in the cross examination. If a person alleges rape, then you have to whether there was any injury, or whether she was known, or it was a love affair. You have to get all those things. So all these things have to be what if there is if allegations of domestic violence, whether if she says that from the day of marriage violence was conducted on me, but then there is no single NC, there is no complaint, and she says that on 2nd of June so and so I was assaulted. So you will have to ask her that, do you have any medical report to corroborate your complaint, or substantiate or support your claim that you were assaulted? And she would say no. Did you get examined by a doctor? She said no. Do you have any documentary evidence to prove? No. Except your bare words, you do not, as of today, you do not have anything to corroborate your claim. And she would say yes. This is how you will cross examine the witness. This is how you will try to get the answers in your favor. Now, one thing, always remember that once when you cross examine a witness, so if you get an answer in your favor, this is a common mistake which a lot of lawyers do, is second time they will ask a question which will totally negate that answer. Don't do that. If you've gotten an answer in your favor, just leave it like that. Don't go more into depth. Don't try to cross examine, or don't try to बोलते हैं ना, जैसे हम हिंदी में बोलते हैं, चीर फाड़ मत करिए. Because if you do that, what happens is, something which you've gotten in your favor, you spoil that and you lose that answer also. So don't do that. Don't do that. These are things which you have to avoid in the cross examination. The first and foremost, what you need to bear in mind is, don't get any new evidences until unless it is not in your favor. Don't get any document until unless it is not in your favor. A document which has not been marked as an exhibit, don't rely upon it. For example, say if there are two documents, okay, and the witness has deposed about this document number one, but not about document number two, okay, and you go and you ask him questions about document number two. If you start asking him questions about document number two, then the court will mark the document number two as an exhibit, because you have asked the questions, you brought it in the cross examination, you have relied upon it. So now the court is going to take it as an exhibit. And if this document is against you, then you are going to be very badly convicted, because you yourself have gotten an evidence in the cross examination which apparently is not in your favor. So try and to avoid that. You would see, I mean, I'll give you a classic example of this. I have a 138 case currently going on, wherein the accused had came up with this defense from day one, that these checks which has been issued by my brother, he is not the proprietor of the company. I am the my brother is the person who handles the affairs of the company. He is the one who got into the transaction with the accused, and he is the one who has apparently uh, got these checks issued. I'm only a signatory. I've only signed the checks, and there is no liability. So during the cross examination, they could not substantiate anything. Now, as defense witness, they brought the brother who is the proprietor, and he went onto the witness box and he said that I'm the one who handles the care of the company. I'm the one who got this check issued. He gave me a chance for cross examination wherein I could demolish their defense very nicely. So during the cross examination, my first and foremost question to him was that, do you have any documentary evidence to show that you are the person who handles the affairs of the company? He said no. I showed him the check. I got the signature proved. I said, the signature is not yours. He said, no, it is not mine. I said, it is the accused number, so one signature. He said, he is the accused number one, is the authorized signatory of the company. He said yes. So my 138, my liability stood proved because of it. Because when his transaction, his defense, I could demolish it in the cross examination, because the defense itself gave me a chance by getting a defense witness to demolish their defense. So it made my case 100% conviction case. All thanks to the defense for it, very frankly. So now coming now to your cross examination. One, as I said, don't get any documents which are not in your favor. Don't get it. If you do that, that will really mess up your case very badly against you. Third thing, what you need to note in mind is that you have to ask relevant questions, questions to which this witness, it pertains to this witness. You cannot ask this witness about something which he has not done or which the IO has done. And how can you can't ask the complainant or something which about an investigation which the IO should have done. For example, if there are no CCTV footages collected, you cannot ask this to the complainant. You have to put up this question to the IO, the investigating officer, because he's the person who's conducting the investigation. He's the competent person who can answer about this, and he's the competent person who has to depose about this. So at the end of the cross examination, you will always take omissions. Now, what are omissions? As I said, something which a witness says in the chief examination but not in the statement. For example, say if I say something in the chief और मैंने उसको बढ़ा चढ़ा के 3-4 और स्टेटमेंट ऐड किया है, जो मैंने अपने स्टेटमेंट पुलिस के सामने जो मेरा स्टेटमेंट था उसमें मैंने नहीं बोला है, I will have to take it from the witness. And always remember, you have to take it particular with each and every witness. देखिए, मेरा ऐसा कहना है कि ये जो आपने देखिए, ये जो आपने बोला है ना अपने चीफ एग्जामिनेशन ये आपके स्टेटमेंट में नहीं है, ये कहना तो सही है, यस क्वेश्चन सो एंड सो हैज नॉट कम इन माय स्टेटमेंट. Can you assign any reason as to why this has not come? And maximum time they would say that, I told it to the IO, but I don't know why the IO has not recorded it. Why you need this answer? Why you need to put up this? The reason being because when the investigating officer is the last witness who comes, and when the investigating officer goes into the witness box, all the omissions are to be put to him. Why it is to be put to him? Because there is something which we call as corroboration. Every witness has to corroborate with each other. So, for example, what a complainant says, the other eyewitness has to say the same thing. The panchas also have to say the same thing. The medical evidences which come has to corroborate a link, which we call as a link of circumstances. That has to be there. That is to be completed. The corroboration is to be completed to convict an accused. If there is no corroboration between the witnesses, then the chain does not get complete, and the chief examination would fall flat, and the prosecution would be unable to prove its case, and the defense will get the benefit of the same, and the accused will be acquitted. At the end of the cross examination, always remember, you have to put up your case. Now, what exactly is your put up? Your defense. Say my defense is that this case has been filed only after, if I tell a wife that, देखिए, मेरा ऐसा कहना है कि ये जो 498 का केस है ना, ये आपने जो अक्यूज है उन्होंने जब डिवोर्स का केस फाइल किया उसके बाद फाइल किया एज अ काउंटर ब्लास्ट. Why? Because this is my defense, and of course the witness is going to say no. But why I have to get this? Because I have done my cross-examination. This is my defense, and I have to put up at the end, which is called as suggestions. I have to put up this suggestions. I have to put up my case at the end of the cross-examination. So remember this. All these things are to be remembered during chief examination and cross-examination. You cannot ask leading questions in chief examination. You cannot ask opinion of a witness in the cross examination. You cannot get additions in the chief examination. You have to stick to your case in hand. And that is the reason I always say this, that when you draft a complaint, be very, very careful. Your first initial complaint only has to be proper, because that complaint is the basis of your whole trial. That is why that complaint has to be kind of bulletproof. It has to be cross-proof, everything, so that it does not fall under the cross-examination. So when I draft a complaint, I always, keep in mind the questions which can come in the cross-examination, and I cover up that also, those lacunas also in my complaint when I draft. So you have to note this in mind. Similar way, when you complete the chief examination, in the cross-examination, you have to get counter answers of the chief examination, not the cross. So you have to cross examine and get answers which will cross, which are cross and counter to what the statement said in the chief examination. Do not get something which comes into your favor and get a counter answer in the cross examination itself. You will wash away your defense. Don't do that. Secondly, don't get evidences, don't get documents which are not effective. In fact, if there are documents in your favor and you know that the complainant is deliberately not produced, you can also call upon to produce those documents to the complainant. So what you can say is कि ये सब documents है, आपने prove नहीं किए, आपने place नहीं किए. You will also notice that sometimes the witnesses are very smart. Okay, if you put a question to them in the cross examination, say कि ये जो document है ना, ये आपके पास कोई भी documentary evidence नहीं है, and they would say कि नहीं मेरे पास है, आप बोलेंगे तो मैं प्रोड्यूस कर सकता हूं. अगर आपके फेवर में है तो आप बोलिए कि यस गेट इट प्रोड्यूस. If it is not in your favor, your next question to the witness would be that can you assign any reason what prevented you from producing that document along with the charge sheet, or what prevented you from producing the document with the complaint. Because you now, once the witness says ki, yes, I have the document and I can produce this is an answer which has come against you. You need to cover up this answer. So your next question would be, but what prevented you to produce that document during the initial stage, so as to whitewash that earlier answer which has come in your favor, come against you. If it comes against you, then you ask a second question to whitewash the earlier answer. If it comes in your favor, leave it at that stage. Don't ask any further questions so that you won't lose the answer which has come in your favor. So I remember when I was conducting a cross examination of offenses under the MRTPI. Okay. So I remember when I asked the officer, I was asking him questions and he was not answering. Only I got acquittal only on one answer, wherein I asked him that would it be correct to say that you never wanted to register a complaint against the accused, but you have registered the complaint at the instance and the pressure of the society? And he said, yes, I have registered the complaint at the pressure of the society. So immediately I stopped my cross at that time. I put up my suggestion, and luckily my client got an acquittal for that. Similar way in a POXO case, when I had to cross-examine the IO, I asked him, he had produced a school leaving certificate. So I put it up to him that, the school leaving certificate is a Xerox, a photocopy. And he said, yes. You do not have the original in your favor. He said, yes. Except there is overwriting, there is material alteration on the document. He said, yes. I said, except this, you do not have any other document to prove the age of the witness. And he said, yes. So this is how you put up the questions in the cross examination. So this is what your chief examination is, what your cross examination is. Over to you, Swatilika.
Thank you so much, ma'am. Ma'am, I just have one question which has come during our sessions. That is, what is re-examination?
What is re-examination? Okay. Now, whenever a witness finishes his chief and his cross examination, and there comes an answer which is ambiguous. Now, what do you mean by ambiguous or the ambiguity? Now, there is the judgment of Rajendra Prasad of Supreme Court which says that re-examination can be allowed if there is an ambiguity in the cross examination. What do you mean by ambiguity? Ambiguity is that you can read that answer in two ways. The witness may have answered a yes or a no. It can be taken in the favor of the prosecution also. It can be taken in the favor of the defense also. During that time, the prosecution will say that there is an ambiguity. This question was put to the witness. The answer has come so and so. This is an ambiguous answer. I may be allowed to re-examine the witness only on that point. So you file an application for re-examination, and you are allowed. The court will allow you if there is an ambiguity. Rajendra Prasad's judgment is very clear. Only in cases of ambiguity, re-examination can be. As a matter of right, you cannot be allowed. If there is a lacuna which has come by the defense, you cannot be allowed to fulfill that lacuna through re-examination.
All right, got it, ma'am. Thank you so much. Thank you, Beekta ma'am, for the very, very insightful session today. I hope everyone has enjoyed this webinar. We will meet again next week on the same time, Sunday, 11:30 a.m., and continue this series with more practically useful topics and information. Please ensure you comment and ask questions and queries at the end of our sessions. Till then, please take care and have a great day ahead. Thank you, ma'am.
See you guys next Sunday.